Ladies and gentlemen, a warm welcome on this very cold Melbourne night. I would like to begin in our customary way by acknowledging the Wurundjeri people of the Kulin Nations, the traditional owners of the land on which tonight's event takes place. So welcome, ladies and gentlemen, to the 2017 Foenander Lecture at the University of Melbourne's Faculty of Business and Economics. I'm Paul Kaufman, Dean of the Faculty of Business and Economics, and it is my pleasure to see so many of you here connecting with the university and enjoying this public lecture. To our alumni here tonight, I just wanted to let you know that I will be hosting our inaugural Melbourne Dean's event on the 4th of October. So I hope to see many of you there. You will receive more information from us soon. But tonight marks the 31st Foenander Lecture. Commencing in 1986, the Foenander Lecture was established in memory of Allan Foenander, a former academic at the university, who was one of the leading figures in industrial relations scholarship in the early 20th century. Each year, we invite a distinguished figure from government, business, the union movement, or academia to present a lecture on contemporary issues in industrial relations and human resource management. This is a once-in-a-lifetime honor. Speakers cannot be invited to deliver more than just one Allan Foenander lecture. It is appropriate then to make some brief remarks about Mr. Allan Foenander, in whose honor this lecture series is named. Allan de Ruyter Foenander was born in 1890. And in 1909, he began a law course at the University of Melbourne. He joined the newly established Faculty of Economics and Commerce in 1926 as a part-time lecturer, and by 1954 was appointed the head of the newly established Department of Industrial Relations. He was the first head of an industrial relations department at any Australian university. Allan retired from full-time teaching in 1957, but continued on a part-time basis to his retirement in 1969. His research was focused on the federal system of conciliation and arbitration. His primary focus was on the economic and protective functions of the federal tribunal. Foenander was interested in the role of industrial tribunals to deal with social problems and the role of unions as agents of change. Foenander passed away in 1985, and we commenced this lecture series a year later, funded by a trust set up by his family. The faculty is extremely pleased to continue honoring Allan Foenander's achievements through this lecture series. I would now like to invite my colleague, Professor Prakash Singh, Head of the Department of Management and Marketing, to introduce our speaker for the 27th Foenander Lecture. Thank you.
Thank you, Paul. The department is delighted that the 2017 Foenander Lecture will be delivered by Professor Allan Fels AO. Professor Allan Fels graduated in economics with first-class honours and law from the University of Western Australia in 1965. He has a PhD in economics from Duke University and was a research fellow in the Department of Applied Economics at the University of Cambridge from 1986 to 1972, where he wrote the British Prices and Incomes Board. The career of Professor Fels in Australia falls in two parts. He was generally regarded as the nation's leading regulator, serving as inaugural chair of the Australian Competition and Consumer Commission and its predecessor bodies from 1989 until 2003. The Australian Competition and Consumer Commission is the country's regulator of competition law and consumer law. It also regulates public utilities in the telecommunications and energy industries in a similar manner to industry-specific bodies such as Ofcom in the UK and FCC in the US. He has had numerous other regulatory roles, for example, in insurance, agriculture, telecommunications, and aviation industries. Professor Fels remains a leading figure globally in competition policy. He co-chaired the OECD Trade and Competition Committee from 1996 to 2003 and continues regularly to be a keynote speaker at major global competition events, including the World Two Peak events, the International Competition Network Annual Conference, and the OECD Global Competition Forum. Second part of Professor Fels' career has been as an academic. He was appointed Foundation Dean of the Australia and New Zealand School of Government and served in that position from 2003 until 2012. The predominant activity of the school has been the provision of management development programs to senior public servants in the two countries. There is also a substantial research program and other professional outreach activities. Among Professor Fels' many appointments, he is also a professorial fellow in the Faculty of Business and Economics here at the University of Melbourne. Professor Fels was made a member of the Order of Australia in 2003. Ladies and gentlemen, please welcome Professor Allan Fels.
Ladies and gentlemen, I'd like to acknowledge the traditional custodians of the land, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders and to their community. I'd also like to acknowledge the important contribution that Allan Foenander made to the study of industrial relations in this country. He was an academic pioneer of the discipline in this part of the world, and his research was foundational for students when I was a student of industrial relations, and for all academics of my generation. So lectures of this kind tend to fall into three parts. The first part, the speaker says how honoured he or she is to have been invited to give the lecture. The second part, the speaker points out with apparent modesty that he or she is totally undeserving of the honour. And the third part is a lengthy practical demonstration of why they are undeserving of this honour. Let me turn to the third part of my lecture straight away. So I want to talk a bit about 7-Eleven, and then more generally migrant workers, and then morph onto the subject of gig workers and Uber. And then finally, I wanted to say a few words about competition law and labour markets. The four bits are not that closely connected, but there are some links. So on 7-Eleven, just to tell you the story of 7-Eleven, it's got about 650 stores in Australia. About 20,000 people were on the 7-Eleven franchisee payroll over the preceding 7 years. Most workers were on student visas. The most typical case was that, with the majority of them being underpaid, the most typical case was a student would work for 80 hours a fortnight, which is double the amount allowed by the visa conditions. You can work 40 hours a fortnight in the visa. And they were generally paid 40 hours a fortnight for 80 hours work, with no holiday super or penalty rates being paid. In some cases, the exploitation was greater, and the underpayments were very fully exposed in Adele Ferguson's Four Corners program and in related exposures by her in Fairfax Media around September 2015. Now, immediate question that comes up is how do you frame this story? Who is, if you like, at fault? Is it the students who break the law? They work for less than the minimum rate. Possibly they threaten jobs of Australian workers and they break their visa conditions. Another possibility is that you want to blame the franchisees. They're the shops, the individual shops that underpay the workers. They're the ones most obviously breaking the law. But maybe you should blame the franchisor, that's 7-Eleven. One of the reasons is that 7-Eleven had a profit-sharing model, and for quite a few stores, probably a majority even, it was impossible to make a profit unless you only half-paid workers. Or if you have a more libertarian bias, was it the existence of our minimum wage laws? Or was it the failures of enforcement of the Fair Work Act? And I'll come back to some of the problems about enforcing the minimum wage laws in this area. Or was it our own education sector? Hundreds of thousands of students are foreign students, and are we doing enough to try to stop them working under the minimum rates? Or was it the fault of immigration policy, trying to bring so many workers here? Was it producer interests who want cheap labour? Was it even we consumers? We all like to benefit from some of the services and products that are made available as a result of cheap labour being used. Now, what 7-Eleven did was that it introduced a voluntary response to the exposure by Adele Ferguson. I just want to mention that the whole matter of underpayment by 7-Eleven was made clear to them before the exposure on Four Corners. In 2007, United Voice complained officially. Then there were two studies around 2011 and 14, I think, by the Fair Work Ombudsman, pointing out what was going on. 7-Eleven did its own audit in 2015, finding extensive non-compliance with payroll conditions. But nothing happened, really, until the public exposure. And then immediately they announced a voluntary response. They were under no legal liability. There's a remote academic possibility that they could have been involved in aiding and abetting breaches of the law, but it's really just about impossible to prove aiding and abetting the way the law is framed. So they had no legal liability, but because of the damaging publicity, they invited me to head an independent panel to arrange for the repayment of workers. Let me just talk about a number of actions that they took. The first one I'd like to mention is that they changed the profit-sharing model heavily, and it gave the franchisees a much better deal. And I'm still slightly agnostic about it, but I would want to acknowledge that it certainly changed the parameters quite heavily for many, many shops. They could operate and survive even though they're now paying the full wage. The next thing is that when they called me in, we agreed. In fact, I insisted on day one, if I'm going to do this, we cannot run it like a court of law because you haven't got any records about the exact details of the underpayment. So I, aided by Deloitte's and by my colleague Professor David Cousins, had an appropriate, sensible process, but one that fell well short of the standards of proof required in a court of law, for determining who'd been underpaid and how much. And there are a whole lot of other very flexible processes that we had to get the thing moving fast and to get restoration of wages quickly. In fact, repayments have reached $150 million already. And of course, nothing like that would have been recovered under Fair Work Act processes. There are very modest fines, and it's very hard to get large numbers of people repaid for underpayment. So I want to acknowledge that this is a very substantial step by 7-Eleven, but also it is fair to point out that the majority of underpaid have not had any pay back. And there's a number of reasons, some of which I'll cover, as to why that has happened. And I was also disappointed when they, as you probably know, they kind of sacked me during the process, that they also closed down an arrangement I had set up to make contact with underpaid workers and to build their trust and their confidence in coming forward, that they wouldn't be reported to the government or lose their visas or whatever. Now, the other thing I wanted to mention about the response by 7-Eleven is that they are determined that this should not happen again, and they have taken very extensive compliance measures. They include, for example, on this question of how many hours people work, they have CCTV cameras, they have now fingerprint sign in, sign out, they have extensive payroll monitoring, compliance managers, inspectors checking up everything that you could think of to prevent non-compliance. There still has been a little bit of non-compliance, but they have changed things very heavily. But it was a huge job to do that. The other issue, slightly more difficult, in fact very difficult, was changing the franchisee culture of underpayment. There's just a culture that everyone was underpaid. It was all over 7-Eleven, and it's all over a number of other franchise operations in Australia and some other sectors. But to change the culture is quite difficult. And in the early days of introducing the measures that I've just mentioned, there continued to be quite a lot of non-compliance by the franchisees. For example, there was the infamous cash-back arrangement where the worker receives the proper pay, it's lodged in the bank by 7-Eleven, the franchisor who manages it, and then the shop owner requires of the worker that half of that be paid back to the franchisee in the form of cash. So that illustrates that not only do you need very good technical arrangements, but you also need to work on the culture, in this case, the culture of the franchisees. Now, so this response demonstrates that much more can be achieved by serious, committed, voluntary actions of a firm when they're serious about it than by formal legal enforcement by public authorities. It demonstrates that extensive compliance arrangements are necessary, especially when there is a culture of non-compliance. And it also shows the potentially powerful deterrent effect of redressing underpayment. I mean, providing there's a credible mechanism to make sure that that happens. But that is a far more powerful deterrent than the quite small fines that are payable in these situations, together with the certainty of people breaching the law that there will be no legal action against them requiring repayment to the workers of what they should have been paid. Now, that brings me to the law enforcement challenge that arose in this situation. What happened in 7-Eleven was that there was very poor, fake or non-existent record keeping, and that made evidence very difficult to get, certainly up to the standard that a court of law would require. There's an interesting question. If employers don't keep records, should there be a reverse onus of proof on them to prove that they didn't underpay? That's being kicked around in the Senate as it debates the Vulnerable Workers Bill at the moment. There are some people who have some serious concerns that there could be some unintended side effects of a reverse onus. Now, many underpaid workers did not come forward. Fear of loss of visa. We asked immigration to try to help us out. They would not give an amnesty. They had some fairly solid reasons for that. They did provide what I call a comfort letter, which makes you fairly certain that you're not going to be deported, but still leaves the door open a little bit. It also says, of course, if you do it a second time, you will be deported. And they also generally try to explain that very few people are deported for this. Now, there's also the fear by the workers of the loss of a job if they take the matter forward to the 7-Eleven wage repayment panel, but especially if they take it to the Fair Work Ombudsman. They want to hang on to their job. Many of them are quite happy to be underpaid, to have any kind of job. They also fear franchisee or other retaliation. And during the 6 or 9 months that I was doing the repayment process myself, there was a very big campaign by franchisees to intimidate the underpaid workers from coming forward. And one of the reasons, but there were a number, was that 7-Eleven at that time said it would fully repay the workers, but send some of that bill to the shops that were underpaying. So that added to the pressure from the franchisees. There is also unawareness of rights and of how to engage with the regulator, some language barriers. The workers may have left the country or would have by the time restitution occurred. A general caution in dealing with the government. For example, the Indian workers were somewhat more confident. The Chinese workers have really shied away from it a lot. They have a deeper distrust of having any engagement with a government. Now, if a worker does come forward, then they have to provide evidence and court acceptable data. And that is hard. They're just very poor records. Hard to win a formal case with that data. And the regulator is not very keen to run a case without proper data. There are onerous, protracted legal processes. There's the whole fear of being in court and being cross-examined. The difficulty, even if the case goes through and there's a fine, of going on to get proper redress. And finally, the fear of just being determined legally to be breaching visa conditions and wage laws. So on the regulator's side, applying the law to numerous franchisees case by case is difficult. And there are many things besides the fact that, there are several hundred companies, you'd have to take action against each of them, get a very modest fine and then determine how much the repayment should be. And there are all these other things. Just the Phoenix companies is one example. That is that the company that's being fined closes down and tomorrow it sets up exactly the same company with a couple of changes of name and maybe directors, some relatives do it or whatever. The low fines are simply a cost of doing business, they're not a deterrent. As I mentioned, the aid and abet provisions are no consequence to franchisors. And reform possibilities to law enforcement are very difficult because of the separation of judicial and executive power under the Australian Constitution. The courts have a monopoly over, I'll just use that emotive term as a competition regulator. The courts have the exclusive right and role to determining that behaviour is illegal and what the fines should be, whether there should be penalties, redress and other legally enforceable orders, and they require standards of proof acceptable to a court of law. So if the separation of powers and the requirement of fines, etc., being determined by a court and the onerous court processes, it's very, very hard to deal with cases where there are thousands and thousands of people who are illegally underpaid. Now, despite that, the work of the Fair Work Ombudsman has been valuable. It's conducted investigations, undertakings, court actions, education, publicity, some interesting reports, and it's had some reputation impacts when it's taken action. But I just want to stress the other side of it, the limitations of enforcement under the Fair Work Act when there is widespread systematic law breaking. Now, the government response in this situation made by the coalition government during the election campaign, they strengthened the Fair Work Ombudsman, resources, investigation powers, higher fines, the Vulnerable Workers Bill, and then establishing the Migrant Worker Taskforce, which I chair. Now, with the Vulnerable Workers Bill, the key provision going through the Senate right now makes a franchisor liable for a contravention by a franchisee if the franchisor, the 7-Eleven if you like, knew or could reasonably expected to have known that the contravention by the franchisee would occur, or that a contravention of the same or a similar character was likely to occur. However, the provision does not apply if the franchisor had taken reasonable steps to prevent a contravention of the same or similar character. So just a few comments on that. There is a disturbing amount of non-compliance with the minimum wage and other fair work laws by a number of franchisors. There have been very high profile exposures again by Adele Ferguson of Celtex, Domino's, United Petroleum, a number of others, which shows it's very widespread. Now, there, you've got the liability now on the franchisor who could know or be expected to know about it, but they can take reasonable steps to prevent it. The law does need to strike a balance. The great majority of franchisors and franchisees are law-abiding, and now they will be covered by this law. Some onus, in my view, should be put on franchisors, roughly what's in the bill. I've always advocated that from the very beginning of this controversy. But not total liability, because if there were total liability, then there would be a huge moral hazard problem. That is, the shops would feel they can freely break the law, and so would the students, and then head office would be legally liable, not them. So there's some kind of balance needed. And there's an interesting question whether this type of law should apply in non-franchise situations, indeed to the whole supply chain. Now, the other action was establishing a migrant worker task force, and that was due to an expressed and real government concern at the very large numbers of underpaid workers, migrant workers. The two big categories are students and persons on working holiday visas, many of them young, but they're on working holiday visas. Working holiday visas, I'm sure you all know, were set up as a cultural thing to allow mainly young people to visit a country, experience it, and then go back. But many of them started to get work, and now most of them get work, and there is huge underpayment going on there. And by the way, that latter category is undermining a previously well-working seasonal worker program for Pacific workers. So our job is to identify further proposals for more effective law enforcement and so on, and to progress cross-portfolio issues, which, have a look at who's on the committee. You'll see that there are many parts of the Commonwealth government, let's not even talk state governments, which have a significant interest in this matter. Obviously Employment and Fair Work Ombudsman, Immigration and Border Force, Education and Training, Treasury, who've got this Black Economy Taskforce, and Tax, very concerned at tax avoidance that goes on big time in this area. The Attorney General's, which has a special interest in a slavery law, which Julie Bishop has just announced the government will bring in, I think the same as the UK one. Ag, of course, is there, and so the ACCC, ASIC, and some other people with relevant interests. The point I just want to make is that there are many parts of the Commonwealth have got some interest in work and underpay and migrants. And previously there's probably no great need to bring them together, but given the extent of underpayment going on, Commonwealth thinks it's got to do more to get cooperation and shared activity going on. It does indicate the many policy levers that are available to address this problem. But it's not as simple as that, because the policy is not just to stop underpayment. There are many conflicting policy areas. Education wants to see as many foreign students here as possible. Agriculture wants to make sure there's a supply of labour to farms and to horticulture. Tax, it's very good to have them on the committee. Their main interest is just chasing the tax avoidance. And immigration also has other, first of all, it's got some higher level interest before you even get to that. I believe they don't want the boats to come, and certain other very high priorities in that department, but they are taking more interest in this now. But also immigration is forever torn between strong pressures for bringing in immigrants to do various things and strong pressures to regulate it. So let me just mention a few general issues that have come up. One of them is the very large numbers of underpaid students and persons on working holiday visas acceptable? We are now up in, not only the tens, I'd say the hundreds of thousands. Can the Fair Work Act be made more effective in preventing and remedying underpayment? Are there any other mechanisms which would assist in preventing and remedying underpayment? Are there any changes in immigration and other policy settings and their applications which could assist? Two issues I want to mention. Labour hire companies. That's including recruitment agencies. The vast majority are fully law-abiding. That suggests maybe that we should focus on one or two sectors where there's a disproportionate number of labour hire companies who are blatantly breaching the law. Labour hire, of course, removes responsibility from the producer, the quote, real employer. Some of them, The worst ones have chains of companies. So you go for a labour hire company and you find it's not actually hired the workers, it's got to deal with another company that's hired the workers, but that company got a deal with, there's a whole chain of labour hire company linkages which make them very hard to track down. And of course the Phoenix company problem adds to it, and the companies may ultimately be located offshore. Possible approaches, in brief, should we register labour hire companies? For the whole economy? I don't think so. But what about in the sectors that there are problems in? That is a matter receiving serious consideration by state governments and the Commonwealth and our workforce right at the moment. Should there be licensing? Before you can be a labour hire operator, should you have a licence? And then you can only, if you're a farmer or someone else, you can only hire labour if you go to a licensed business. In the UK, they have the Gangmaster Labour Abuse Authority, which does that in a couple of parts of the UK economy. One other thing about licensing and registration is that it is a potential way of overcoming the constitutional problems I mentioned. In other words, it could be a condition of getting a licence that there's no underpayment of the workers, and if there is full redress for them as a licence condition or as a registration condition. That is one of the attractions of a licensing or registration solution, but everyone knows that licensing and registration approaches, just wherever you have them, can be extremely onerous, misdirected, and have heaps and heaps of problems. So it's just a matter that needs a fair bit of debate. The UK has recently, interestingly, established David Metcalfe as the Director of Labour Market Enforcement. His job is to bring together all the different arms of labour market enforcement in the UK, including labour hire, recruitment agencies, minimum wages, some other things. Interesting idea for us to think about. Now, I also just wanted to mention problems caused by migration rules. The 40-hour rule for students. Now, there's evidence of massive non-compliance. Most of the hundreds of thousands of students here, foreign students, work, and most of them are underpaid, break the law, are exploited, whatever you want to call it. So the numbers are very big. Now, one thing that makes it worse is the rule itself. I mean, the rule, there's a very elaborate, strong defence available of it. I fully understand why it's better to have a rule than no rule and things like that. But the existence of the rule is a problem because it sets up situations where the students very quickly have broken the law, have broken their visa conditions, and then the employer can put pressure on them, exploit them, threaten them, and so on. Likewise, with seasonal workers, there's the so-called 88-day rule, which says if you actually work 88 days a year or more in year one, and the employer verifies that, then you can stay for a second year and work. Now, again, that's somewhat defensible, but it does cause a serious problem in that the workers are then very much at the mercy of the employer to send the letter confirming that they've worked 88 days. Some things are being done about it, smart administrative things, requiring payroll evidence and things like that from the employer to tighten up the handling of that. But I just raise this issue that these rules, which sort of make sense, are causing some problems. And again, I just mentioned, it seems to me it's such a big problem, the education sector has to do something about it. And there will be reputation issues for Australia. The Indian press is going to get onto this one day. And there are other reputation problems. Okay, gig workers and Uber, which is another sort of interest, a little bit connected. I just mentioned the whole idea of independent workers. There's some characteristics: autonomy, payment of tasks, short-term relationships, maybe 20 to 30% of the working population, maybe. Then I'm sure many of you are familiar with the work of Wheel, who points out that there's been a shift away from businesses directly hiring workers to them not hiring the workers, and the workers work for a non-producing employer who maybe specialises in labour hire. So many workers have another sort of non-producer employer. Some are independent contractors. And so we have this phenomenon of the fissured economy where the workforce is separating from the real user of the labour. And there's a whole set of explanations of that financial market pressure on employers. The fact that there's technology that, even though you don't directly own the workers, you can still set standards of quality control and so on using technology. So one point I just make in passing: for better or worse, this separation of workers from their people who are at their place of work makes labour markets more competitive, for better or worse. In other words, the choice of workers can be subject to more competitive processes. Now, I've also just wanted to, obviously we need to think about some of this, and here's one way of describing the problem, which I took from McKinsey. So you see on the left up the top, the preferred choice. So if you're looking at independent workers, some of them are free agents. They just want to work independently. It might be a carpenter, a plumber. They just choose that. Going across, there are also a number of casual earners who just want to do that. They want to do some independent work to supplement their income and to do so by choice. They might have traditional primary jobs. Others might be students, retirees, caregivers, and they just pick up some part-time work, and it's their preferred choice. Now, another category is others who grudgingly do it, necessary choice. That's people who are really reluctant to do it for their primary income, but they just have to do independent work. They can't get a job. And then finally, in the last right-hand bottom, there's people who are financially strapped. They have to do independent work to supplement their meagre income. They prefer not to have to do these side jobs. So I just want to sort of bring out the point. There are many ways of analysing this problem. Here's one that I found quite instructive as a first way of thinking about some of these matters. Okay, now, because of time, I won't tell you any anecdotes from the taxi inquiry, but just on gig workers, which is a category of, I guess you'd call it independent worker. Gig work, you take a gig, you know, Saturday night you go singing, that's a gig. So it's on-demand work, usually done off a digital platform. Mostly the worker supplies their own tools and place of work, paid piecework. They're a small but growing part of the labour force, less than 1%. Most are part-time. There are some full-time. Many use it to supplement their income or fill in gaps in the day. There are a number of pros: flexibility, control of work to a degree. It supplements or smooths incomes. It provides great opportunities for certain demographic groups to get work. Cons. Risks from the insecurity of the work. Labour market regulatory protections may not apply, and usually holiday penalty and super don't apply. Uber, it's very fast expanding. We've got 5 billion rides have been recently registered. Fills a gap caused by a rigid system of taxi regulation, where it's allowed. To a significant degree, it expands the market rather than displaces taxi drivers, although my taxi driver today, as I was coming here, gave me a little lecture. Well, I was trying to think about this lecture about, well, he hadn't been displaced, but his income had fallen. What the customer, in case you don't know, you book on the internet, you use a credit card, you don't pay on the car, fairly predictable arrival times. The trip can be traced on a map. Drivers are rated out of 5. Surge prices so that when there's a shortage of supply relative to demand, prices go up. Safety, there's less of an issue with pre-booked service. Most safety problems occur with so-called rank and hail, that is, when you grab a cab in the street. That's really when just about all the incidents occur in taxis. Now, Uber drivers do participate. They check your licence, driving history, criminal checks, car checks, vehicles self-owned and costs met by drivers. Insurance, basic insurance by the driver, but there's an override by Uber. Drivers choose if, when, where, how long to work and can choose to take or ignore trips sent to them. There are no shifts. And very interestingly, they can do other work or jobs, and in particular sign up with non-Uber suppliers of ride sharing or use the multiple apps on the internet. A lot of Uber drivers in the US will also take Lyft jobs, and in some cases they'll take taxi jobs. The ratings is an important form of feedback, and it's a very dynamic supply and demand adjusted type of market relationship going on. Now, many drivers welcome the self-employment. Many drivers are part-time. Also, it does provide a lot of additional work for women, stay-at-home parents, retirees, students, people with disabilities in some cases, other people struggling to get work. McKinsey considers most drivers are independent by choice. Are they employees? That's a question under litigation in the UK and other places at the moment. How well would labour market regulation work if it applied? Policy options, well, suitability of current laws. The other side of it is the competition question. They're still kept out of a lot of markets. Germany, Spain, Italy, much of France and so on, for example. Portability of benefits. And you know there's an international debate, the Taylor Report, Aspen Institute, MIT, etc. I just want to briefly touch on my favourite hobby horse, which I normally require several hours for. But it was on my mind a lot at the ACCC. Competition law has headed down that direction for many years, promote competition. Labour law has done the exact opposite direction, promote collective bargaining and monopoly arrangements. Should that continue? Should the same principles apply or not? Now, there are 3 approaches. One is to exempt workers and unions completely from competition law, except where they take part in a product market cartel. Another is to give them exemptions for employees or unions, but then the question is, where do you draw the line? It's very interesting. Product markets cover, labour markets don't cover, but there are all these intermediate categories. The Australian Medical Association was saying to me, well, we're a union why are you going after us? You're not going after conventional trade unions. And there are a number of tricky questions about where you draw the line. Now, another belief, if you're libertarian-minded, is just don't give them an exemption from the competition law. And there is a school of thought that says that in Australia and elsewhere. But I'd just say to those people, if you really want to free up labour markets and reform them and make them more competitive and efficient, the answer is not really to apply the Competition Act. The answer is to free up the labour market regulations and weaken and abolish most of the industrial relations laws. And also, competition law is not particularly well written, structured, framed to deal with questions of restrictions on competition in labour markets. Secondary boycotts, should they be covered by industrial relations legislation only? They're not. They're covered by our industrial relations law. And the argument which has been brought up, invented, whatever, put forward, is that secondary boycotts are very different from employer-employee conflicts. I mean, industrial relations law is about a fight between an employer and employee, but a secondary boycott involves a third party not involved in that relationship, and the law about that is not very appropriately applied to secondary boycotts. Another view is, well, we want to stop secondary boycotts. The only serious law enforcement agency in town is the ACCC, so get it to do it, put it in the Trade Practice Act. I've heard that from 1 million people in the coalition. And then another point for the competition people in the audience is that the whole of the competition law is about, it's not about harm to individuals. Competition harms individuals. It's about harm to competition as a whole in a market. But these secondary boycott provisions are not about that. They're only about harm to individual employers. There's a bit of an inconsistency. And then this question of where you draw the line. What about farmers? The law applies to them. Small business, they all want exemptions. You can, under the law, get certain exemptions by applying to the ACCC. So, and the final point I want to make is that the Australian exemption is unusual internationally. Internationally, there's generally an exemption for collective bargaining or industrial relations or unions. In Australia, it's an exemption for employees. And there are a number of people who are not employees who belong to unions, like the TWU, and the Act applies to those independent contractors who are in the TWU or whatever, and they have to get authorisation. They often don't get authorisation. But it is really significant. The Act only exempts employees. All these new forms of independent workers, gig workers, independent contractors, franchise, etc., they are covered by the Act. So that's a quick run through 3 topics which are somewhat related, and thank you for having me talk to you.
Well, thank you, Allan, for your observations and comments on migrant and gig workers through examples such as 7-Eleven, Uber and others. Now I invite the audience to ask questions. We have 2 roving microphones in the theatre, so if you would like to ask a question, please raise your hands and we'll bring the microphone to you. At the back up there. So Greg at the back up there first, and then
Thank you very much, Allan, for your interesting and provocative review of these important areas. My name's Greg Bamber. I'm at Monash University. And I wonder if I could invite you to reflect just a little further on your closing remarks about the workers in the fissured economy, the gig workers. My question really is, what about the workers? These workers are not generally enjoying the benefits that are offered to employees, as you mentioned, benefits like sick pay, holiday pay, long service leave, parental leave, health and safety, protection and so forth. So the workers in Uber and other gig forms of employment are in a sense second-class workers because they don't have most of those protections in employment law. To what extent is that fair, and is the unfairness going to precipitate moves to change the definition of these workers, and generally what is to be done in this field? Thank you.
Well, it is, obviously it's an issue and so on. You probably think I'm biased. I do catch Uber a lot. I do hear a lot about Uber. There has been a fair bit of research in the US. And the typical Uber driver that I meet is not a badly off person. A very large number are people who are topping up their income, or they are people who want a few hours work a week. I actually studied the taxi industry in some detail, and we did devote a lot of space to underpaid taxi workers. And we did make some proposals which were accepted to increase their share from 50 to 55, and we took some accompanying measures to make sure that worked properly and was not evaded. So I have had a significant interest in this topic. I'm on just the advisory board of Uber, so I'm not on their board, and I'm free to say what I like. I have not really had the impression that Uber drivers in Australia or in that many countries are particularly badly exploited, but I'm willing to hear the evidence. I do say to an academic audience that we need a bit more research on what's going on. There is a bit in the US, and it indicates, first of all, that each gig market requires its own analysis to some degree. And Uber is not entirely typical of the average run of them, but it gets all the publicity. Secondly, that sometimes Uber cuts prices for competitive reasons, and there's a very interesting discussion about whether that actually hurts or helps the income of Uber drivers because it causes there to be a higher demand. So obviously the matter is up for debate. Most of the drivers I know, of course, they have to own their own car. Now, you may say, well, that's grounds for exploitation, but I tend to think of it, this person owns their car and they're using it now to earn a bit of income. And the average Uber driver I don't see as being particularly poor or exploited, but more as a topping up person. But let's see, let's do a bit more research on it. I believe the Fair Work Ombudsman is looking into Uber drivers and whether they are employees. In the UK, there's a case which the Employment Tribunal found that they are employees, but that's on appeal.
Thank you.
Thank you. My comment is not a question. My comment is about gig work. The reasons why the proportion of people engaging in gig work is increasing. We've been employing for about 30 years, In our experience broadly, there are two trends. Firstly, the companies don't want to employ workers because of increasing regulations and reducing work ethic. And secondly, on the other hand, people also do not want to work for a boss. There's an interesting book called Narcissism Epidemic. Narcissism around the world is increasing. So people don't want to work for a boss. They're increasing insubordination, and also they're getting generous dole. They feel, why should they work? So I think there are two broad factors at work. Your comment on that, please.
Well, they're both very good observations, and I wouldn't really dissent from either of them. And I'd just add, I'm sure you would have if you'd had more time, that Wheels' work spells out in more detail why firms, or what do they call it, lead firms or lead generators are separating from their workforce now, and technology enables them to do so because that technology can be used to set quality and other standards.
Allan,
Malcolm.
I have a question about Uber again. It's prompted by concern for your welfare. You noted how growth of Uber's drawn down taxi drivers' incomes, and also that there's no cap on their hours. Is the research evidence to suggest that because of the lack of a cap on their hours, they are working longer and longer hours, perhaps having more accidents, putting your life at risk when you use Uber? Are you concerned about this? What's the evidence?
Okay, I don't know there is that much evidence either way on this at this stage. With the taxis, maybe this is relevant. The way I've always thought about deregulation is that very often it expands the market. A good example is telecommunications. There's such a hullabaloo when we deregulated and there were going to be losses at Telstra, and there have been big losses, but far outweighed by the increase in the number of jobs in the sector as a whole. Uber has very significantly expanded in quite a few markets. The one we all know about, San Fran, because that's where Uber is, and it's been measured. The market is about 5 times as big as before. In Chicago, huge areas of the city were no-go. Now Uber goes there. And here I believe there's been some market expansion. So it's not entirely at the expense of the taxi industry, but there's probably been a reduction in the number of taxi jobs as a result of Uber's entry. Now, on the question of hours, there's no lower limit, of course, on hours that you can work if you're an Uber driver. You just have your car and you show up and you work for 1 or 2 hours a week, or as many hours as you like. On the question of whether they work too many hours as opposed to taxi drivers and so on, I'm simply unaware of data. I've not heard a great deal of complaining about that fact, but there may be some. I just make a bit of a point that there are obviously problems at Uber, which we read about every day, but there is a very well organised opposition to it, which is extremely good at putting out stories about what's happening at Uber that are not necessarily true. One of them is, for example, a taxi guy tonight. You might ask what I was doing getting a taxi, but we won't go into that. He said they don't pay insurance. They do. Uber has a base, or more than a base, it has a strong supplementary insurance protection. You'll constantly hear from the taxi industry that there's no insurance when you go with an Uber car. So I just don't know about this, whether there is heavy overworking, what the safety record is. I've not really heard anything much to the contrary.
Susan. There's quite a few. Okay.
Yeah. Hi, Alan. Thank you very much for your talk. My question is, in light of the proliferating forms of exploitation that you've talked about tonight and their connection to increasing wealth inequality, pressures on regulatory bodies or resource pressures on regulatory bodies, the fact that automation is expected to displace 40% of jobs in the next decade, I just wanted to know what your view was on universal basic income as a policy response to what is becoming a pretty crap labour market situation for young people.
So obviously in this time I can just give you a couple of short opinions. So just my opinion, to the extent it interests you, is first of all, I do not think we've reached a stage where there will be a reduction in the number of jobs in the economy. It's been forecast for a long time, it hasn't happened. Fact is that the main determinant of the level of unemployment in the economy continues to be macroeconomic policy, and the rises and falls we've had over the last 50 years have all been due to fluctuations in aggregate demand, spending, monetary and fiscal policy, etc. And I see no signs of that situation changing. And I also believe the other, if I can put it this way, Economics 101 point still holds reasonably well. Macro policy determines the level of employment at this stage, and also that at, quote, full employment, there will always be significant frictional and structural unemployment. That's a serious problem. And there will also be winners and losers from the process you talk about. But I'm not expecting to see a rise in the general level of unemployment for some of the reasons I'm getting at. But of course we should be doing something about it. Training and retraining people at work is really important. Everyone has a right to retraining throughout their career. That should be a new motto. On the universal basic income, I'm worried about how it's paid for. And I think I would prefer, with all its faults, a more targeted system of welfare protection, such as we have at the moment. In other words, I wouldn't want to drop our social security system and go to universal basic income. And also something I know all about, because I'm head of the National Mental Health Commission, I certainly wouldn't want to see the funding that goes into various bits of mental health dropped in favour of just giving an income to almost anyone, including those with mental illness. I prefer higher priority be given to some of those people, to people with disability, to certain other categories of people that we do get under the social welfare system. So that's my quick opinion on that. We could debate it all night, I'm aware.
Okay, well, one last question.
Thanks. Susan Ainsworth, University of Melbourne. Alan, can I just go back to the 7-Eleven and the underpayment of workers in the franchises? In terms of the response, one of the responses to that was the proposed, I think it was the bill around franchisor liability.
Yep.
That if they know or reasonably could be expected to know underpayment. Yeah. And I'm just wondering about the economics of the franchise agreement. So between the franchisor and the franchisee, if that's such that it's extremely unlikely that a franchisee would be able to actually run a business without underpaying workers, to what extent can that be taken as evidence that the franchisor could be reasonably expected to know underpayment was occurring?
Okay, so there's an explicit statement in the law, I didn't go into it, about what constitutes reasonable steps. And one of the steps would be to find out if your profit sharing formula is going to put someone out of business. It is, however, interesting, as economists would recognise, all, marginal phenomena. So no matter what profit sharing approach you have, generous or ungenerous, there'll always be people at the margin. Say it's very generous, then a whole lot of less profitable, less efficient people will come in and survive under that heavy umbrella. Then if it's tightened, they'll lose their jobs. Now, what is happening at 7-Eleven is that there are some closures of 7-Eleven stores, because even with the new formula, some of them don't seem to be viable. I don't know the numbers, and I say it with some caution, but we do know some have had to close down under the new arrangement. So there's some very tricky trade-offs involved in this area.
Okay, well, we have run out of time. But thank you for your questions. Ellen, here is a small token of appreciation on behalf of the department.
Very
Please
good.
join me in thanking Professor